If you want to make me a co-host too, I can watch. Okay, cool. All right, y'all. Uh, well, welcome back. Thanks for being here, and thanks for the folks that weren't at the last meeting for being here as well. I wanted to, so a couple things. So for folks that were not here, I'm gonna bring up the slide in which the directives we were talking, and then I want to go through our survey. I think we have a pretty robust discussion ahead of us as it relates to the victims advocate side of things before we get into the legal potential legal exemptions, etc. So for those of you on the panel for the legal side, so that's Jill, Kevin, and Chris. Are y'all able to you're here for the full time, I'm guessing?
Yeah, Chris is joining. I just sent him the link, so he'll be here
There's
in a minute.
Chris. Okay. Chris, are you here until 10? Are you able to?
Yes,
Okay.
yeah,
Okay,
I should
cool.
be able to make that work.
Okay, great. So if y'all are okay, then we're gonna just not start that conversation yet, and we're gonna return to kind of wrap up the conversation from the last meeting around victims advocates, because I think some people are still wrestling with some things that I just kind of want to bring up. And Jennifer, you had appreciate that you're back as well, so I think we can kind of dive in to some of this and get to a little bit more clear of a spot for across the group, and then we'll move into our panel discussion for the legal side. So, as a reminder, the two directives I'm going to drop into the chat that we spoke about last meeting. And we had a panel and we kind of wrestled with some of our questions. A lot of our panelists, actually, I think our whole panel was, or most of our panelists were proxies. So I do think that having folks here to be able to kind of jump in. And Soledad, appreciate you coming back and being a proxy for Roshan again. These are the two directives we're really still on that I just put in the chat. Reporting timeframes when domestic violence, sexual assault, or stalking is involved, and reports involving children and youth who are the victim of dating violence or sexual assault. So I want to just show you the survey that we sent out, and I had 7 responses. So we do have a kind of a starting point, but we're pretty fairly split on the first question of a potential full exemption. And so we have a couple of different, like, here's what we would like, really like from our panelists, here's what we're really asking for. And we have a version of that. I think that's where we're still kind of stuck on, some concerns and some questions that we need to kind of get through. Then there's a couple of other tiers of like, all right, if not a full exemption, then we're looking at a potential, a potential delay and or is there a difference when there's like someone involved in the safety planning with a minor, those sorts of things. So let's look at the first one and let's sit in that space first, which is the question around this. Actually, I just had some more responses. Who got in there? Who snuck in and took the surveys?
I did it right before the meeting this
Jennifer.
morning.
I was like, wait a minute. Okay, so actually, I'm not going to go to my slides. I'm going to go live to the survey because the data is a little different now. So that's totally fine. So let's go here. All right, so here's, and sorry, this is a little clunky, but I think this is going to be better to have the actual numbers that folks have now put in. So here's the first question. So would you support a recommendation to remove victims advocates from Colorado statute list of mandatory reporters? Folks went in and looked at the database that Brian has put together to be able to see that this does exist in varying forms across multiple other states. Colorado is, if somebody could remind me of the actual number of how many states include victims advocates, and I think Colorado, so maybe Jordan, if you have that number, we can come back to that in a minute. But
8
8?
specifically call them out, as victim advocates.
Yes, 8 specifically call out. So here are the comments that folks provided, and I'm just going to give us a minute to read through these. So this was, whether someone voted yes or no. This is kind of what folks are wrestling with, and I just want to put this on the table so that we can kind of like jump in to these questions and concerns. So I'm going to give you a minute to read through these, and then I'll scroll down. All right, I'm gonna go ahead and scroll. All right, everybody good there? Okay, so let's stick in this question. You know, would you support a recommendation to remove victims advocates from Colorado statute list of mandatory reporters? From what I'm reading here, the real question is around like when it involves minors, that it just feels that's kind of where folks are. So what I want to start with, and Jennifer, maybe this is you, but I want to start on the folks that said no, because we do technically have a majority on the survey that said yes, you would be comfortable with this. So I really want to hear from folks that are like, I'm not comfortable with this. Either I'm kind of in between, or I'm a hard no. And want to give you an opportunity to kind of bring forward like what what questions do you have? Do you have questions, or are you just like, no, I'm just a full stop no here, and that's just kind of where I'm at. So Jennifer, we'll start with you if you fall into that bucket, and then we'll move on to other folks.
I don't fall into that bucket, but I have just one little piece of context I didn't see in any of the notes or the minutes that I wanted to throw out before we have that part of the conversation.
Yeah.
Which is that we have actual research that shows that the existence of mandatory reporting requirements for victim advocates discourages adult survivors from seeking help. So, we are creating a barrier for the parent to get safe and to get the children safe by having advocates be mandatory reporters. And I just wanted to say that piece before we go any further.
Yeah, appreciate that. If you want to, some people might be interested in like what that data is or where that data is. So if you have anything you can share, that'd be super helpful. But
I will
particularly
track that down.
Okay, but particularly as if there is a recommendation around this, that could be a citing as to like how this group felt most comfortable. So if folks are comfortable enough, I want to hear from people either that responded via the survey or just are kind of like sitting here with some questions, or yeah, what are some questions you have or concerns you have around this idea of removing?
Trace, I'll jump in. I mean, I'm sure it comes as no surprise because I've been pretty vocal about it from the beginning that I don't like exemptions because I think they create loopholes for children. And I respect what Jennifer said. That's not at issue for me. What's at issue for me is making sure that we have some process in place. I voted no, but sometimes the questions are really hard because they're gray, right? It's not necessarily a black or white issue for me. What I get concerned about is if I want parents that are in domestic violence situations to get help, and I want them to do so in a safe way that doesn't exacerbate the situation. So my thought was, and I was the first comment on the survey, was, I don't like exempting things just based on title. I'm somebody's job title. That concerns me. I would rather us have some protocols in place that say, that reporting doesn't need to happen within, the first 48 hours because they're in a safe place and safety planning is happening. That felt more comfortable for me than just to say, nah, victims advocates they're not mandatory reporters because they're trying to protect an adult client. And I think what we need to remain focused on is this statute is specific to children and protecting children and making sure that their best interests are served during the process. And so I guess that's where the red flags kind of pop up in my mind is, we are about protecting children. We should be about protecting children. And in what circumstances do we have, and in what situations can we continue to protect children and support families that are trying to seek help. So I didn't feel comfortable just saying, by profession or by title, because it just feels like that could leave some wiggle room for someone just to say, oh, I didn't have to report because I'm a victim's advocate. I'm a self-proclaimed victim's advocate. So, I mean, at what point does job title really come into play here? So that was kind of my concern, because I've seen titles just thrown around, usually for the benefit of the person. So that's just my own personal concern that I have to bring to the table here.
Thanks, Zane. Aletha, you want to jump in?
Yes, thanks. Typically when families are involved or victims are involved with advocates, there's already been a crime reported, right? Law enforcement is typically already involved, which then entitles them to that victim advocacy. I may be wrong, but that's my experience, right? So I think limiting their responsibility to the adult, meaning if through their advocacy they find new crimes against a child, mom admits that dad did X, Y, and Z, or her partner did X, Y, and Z while they were still together, and that had never been reported to child welfare and or law enforcement, then I would not be comfortable giving an exemption, a blanket exemption to those advocates, because we would be missing out on victims, child victims, and what would that lead to?
Jennifer, and then Soledad, and then I want to jump into and make sure that I'm kind of understanding a couple things.
Yeah, I'm going to clarify first what victim advocates are. There are two types of victim advocates. There are the kind of victim advocates that I think Aletha is talking about, which are associated with systems. They're part of the police department. They're part of a district attorney's office. They have no confidentiality. They work within that system and are a different kind of advocate. And Colorado is confusing because we call them the same thing. Then there are community-based advocates, who are the people that we are talking about in this context. They're the folks that work at domestic violence agencies, sex assault agencies, are outside of the criminal legal system. And those advocates have a level of legal privilege that is actually incredibly significant. It's better than HIPAA. It is a very tight, very powerful kind of privilege. Those are the folks we're talking about exempting. Those are the folks that are having to breach confidentiality in order to make a report. So we're talking about two different systems. So not all domestic violence is a crime. In fact, the vast majority of domestic violence is not. It is coercive control. It is psychological abuse. It is a lot of things. It is not a crime. And I think there's a lot of misunderstanding about the impact of domestic violence on children. So what often happens is that the existence of domestic violence is perceived as by folks maybe who are not within the system, or folks who are mandatory reporters who are worried about complying with the law, that all domestic violence does impact children. There's no question about that. But whether it's child abuse, whether it is reportable, and whether we can trust the survivor, the victim who is coming for help, to be taking actions to protect their children and to keep their children safe, and that we as advocates can then help them facilitate that before CPS gets involved and goes and contacts the person who's being accused, and increases the safety risk and increases the danger to both the adult survivor and the children. Those are the kind of things we're talking about. So I dropped the very short link from Casey in the chat about the research. There's a much longer article, and I haven't found a link to it that doesn't just take you to the abstract. So I may have to email the actual article to all of you, but I'm going to stop and let Soledad jump in.
Thank you, Jennifer. Jennifer did a great summary of what I was going to say, but I'm going to wear my past former shelter director hat. So I was a shelter director domestic violence shelter director, and I manage a team of about 20 between overnights and shelter advocates and crisis line advocates. Not all the victims, as Jennifer said, report to the police. So that's a given. I think I'm not 100% sure about the percentage, but it's pretty high. Two, I can tell you myself, I have responded to crisis calls that when we disclose that we are mandated reporters, the person will hang up because they don't want to get involved in the system for various reasons. I will say for me, one of the most challenging things for an advocate is to lose someone on a crisis line that is reaching out for help right after you read your little piece of disclosure. So you will say something like, my name is Soledad, and I want to tell you before you share anything with me that I'm a confidential advocate, but I am a mandated reporter. So if you disclose any type of child abuse to me, I will have to report. So that's the first line you say. And I can tell you many, many times you get the thank you so much. And we lose them because we don't track their numbers. We don't know, we still don't have any information. So that's one. Two, in shelter, I lost clients that were at shelter the minute we make a report, and they will leave because they know how dangerous it is to get involved with the abuser at that point. Right after they leave is the most dangerous time for a survivor. We all know that. So I think that as Jennifer said, we need to separate the avenues. When there's system involvement, that's in the hands of the criminal system, that's there, everything is moving. When a survivor is reaching out for help to a community-based advocate, that's different. You want to build a relationship of trust so you can serve that survivor, in the most efficient way, in a meaningful way for them. If I start a relationship saying, by the way, anything you tell me, I'm going to have to call on you, and these are the consequences, like that challenges that trust that you're trying to build to be able to provide services. And also, I want to say that when someone is reaching out for help, they are in active trauma. Whatever is happening, they are in active trauma. So they are in a flight, fight, risk response, right? So they're like alert at everything you say, and if anything sounds threatening, they will fly. And that's the reality of it. So the impact of breaking that trust and challenging that confidentiality aspect of community-based advocates is huge on survivors, and is huge on the day-to-day work. So that was my 2 cents in the conversation coming from an advocacy perspective.
Thanks, Soledad. And I do appreciate the, Jordan, I'm wondering from our perspective, like the call out of the community-based advocates versus the, systems involved, or, how, like, if that delineation is like what we're actually getting at as it relates to the directive.
Yeah, you must have been able to read my face because I was just kind of trying to track down the statute as it currently is written. Defines victims advocates in 1390-107, which I have up here, and I'll just throw that in the chat. And by the way, we can recommend whatever we want, but right now, and I appreciate that the organizational advocates that Jennifer talked about are probably captured in other professions listed. But I just wanted to see, of course now my stuff is too long.
That definition you're talking about, Jordan, only applies to the community-based advocates. That
Correct.
doesn't. So that.
My question is, in writing the recommendation, would we need to expand on that definition? Because if we just were to strike what's in there now, I don't know if it would get to what I think I hear some members of this group saying, or if we could keep that delineation in place. Does that make sense? I was just trying to make sure I was understanding as we were talking so I could draft recommendation that reflects what we're trying to get at.
And actually, thank you for dropping this in the chat, because I think that's incredibly helpful for folks. And I can be a little bit more clear about who are mandatory reporters by this statute, which is only victim advocates who work at a program that primarily serves victims of domestic violence or sexual assault who have undergone specific extensive training, which you'll see in the statute. It delineates it very specifically. So we're not talking about every victim advocate. We're not even in a community-based program. We're not talking about every agency that might be in your community that serves victims. There are some agencies around the state that serve victims of all kinds of crimes. And if it's that broad, it actually doesn't fall under this statute. If they partner with law enforcement, which in some rural communities, the local community-based program is the responder for law enforcement, they are not addressed in this statute. So we are really talking about the shelter situations that Soledad is talking about. We're talking about rape crisis programs. We're talking about programs like I used to work for, Project Safeguard, that provides legal advocacy to survivors of domestic violence, sexual assault, and stalking. But both the program itself and the individuals have to meet the criteria that are in the statute in order for them to be mandatory reporters by definition under this particular statute, but to also be exempted. So the flip side of this in this statute specifically is who may not testify without consent. So this is the state statute that grants the privilege I was talking about earlier, that is very broad and pretty all-encompassing, except for mandatory reporting.
So I'm going to jump in then, because Jill, you actually made the point I was just about to make based on the language that was dropped in. Jordan, I think super helpful that there is a little bit narrower of a scope than maybe some folks were thinking as to the who is and who is not. So Zane, I think that speaks to the self-proclaimed advocacy piece. Then I'm seeing your second question though, around the how it got here today, and it looked like I think Jessica daughter said that she could jump in. So yeah, why was that added? So Jessica, I'll hand it over to you, and then Kathy will come to you as well. Now you've had your hand up, sorry.
Give me 2 seconds if Kathy wants to go first. I had it in my notes because I talked about it last meeting, but let me just pull those up.
Okay. Jessica's like, per my previous email, we're like, okay.
Sorry, that's not what I meant. I'm just like, I remember I looked it up last
Touche.
meeting, and I might not have gone into detail. Sorry.
Touche. Okay, Kathy, you want to jump in real quick, and then we'll circle back to Jessica.
Yeah, I think I just wanted to sort of echo some of Zane's comments. Coming from I think this is such a complex issue, right? Because what ultimately I think we all want is to support kids being safe and the families and the people that are around them. And I think the challenge for me is really trying to understand, are we, if we're talking about people that may have unique opportunities to identify where kids may not be safe, as complex as the situations are, does that still fit in the responsibility? And like as Zane said, do we work with other ways to make sure that we can mitigate the potential risk, like allowing a delay, allowing longer time period before the report is required to allow some safeguarding. I'm just going to put in the chat some articles from the pediatric literature that really talk about the intersection between intimate partner violence and child abuse and the risks to kids. I think we would hope that there are other eyes and there are other opportunities of mandatory reporters that can make those referrals to protect that relationship, but I don't think those things always exist. And I think sometimes the only eyes might be the victim advocate. And so how do we sort of walk this line in protecting that relationship so that people will go to those folks, but also making sure that in those circumstances where they maybe are the only eyes, there is some protections, because there's a lot of reasons, as we know, why someone may not be able to in that moment adequately protect or safeguard the kids. And that is where I think sometimes systems do have to step in. So anyway, I just wanted to sort of go on record along with what Zane was saying, thinking about that sort of child safety perspective and why these laws were put in place. And think about something that maybe doesn't just create a full exemption, but put some other things in place to help support the advocates in their role, but also maintains that protection of kids.
Thanks, Kathy. Jessica, are you ready to jump in?
Yeah, so I had looked it up because I was interested, right? And like, when did victim advocates become specifically called out as mandatory reporters? It happened in 1995. And they actually, sometimes when they pass bills, they add legislative declarations that talk about the intent of the bill. And so this one, I believe they might have added, it looks like they only added advocates, but they talk about a couple of reasons why. And they say that the General Assembly recognizes that sexual assaults pose unique problems of great magnitude facing many Colorado citizens, and that the victims of sexual assault suffer physical, psychological, emotional, and financial injury as a result. Because of the fear and stigma that result from these crimes, many victims hesitate to seek help even when it's available at no cost to them. As a result, they fail not only to receive necessary medical care and emergency counseling, but they lack the psychological motivation and support necessary to report the crime and aid in a criminal investigation. The General Assembly therefore recognizes the need for a more sensitive and unbiased approach in dealing with sex assault victims and investigating and prosecuting crimes. And then they go on to declare that in order to ensure the prevention and reduction of crime and ensure the safety, health, and welfare of all Coloradans, it's necessary to revise statutes governing the provision. This is where it kind of loses me, of medical treatment for sexual assault victims and the methods applied by law enforcement in investigating and prosecuting sexual offenses. So it might have been, right, leg decks are written in a very like poetic way to try to oftentimes not only lay out the messaging for the bill, but I mean, to provide a statutory like authority for what the intent is. The bill probably did a few more things than add victim advocates. It was probably a small piece of that. So that's kind of what we have in terms of quick looking at the reason why they were added. Any of you who have been in the legislative process know that when the bill opens up, groups come in and say, do this, do that, add this, take away that. And so, it kind of fits to me under that legislative intent in terms of the idea that counseling and psychological assistance helps support survivors through the criminal justice process. It was obviously very specific to sexual violence in there. So I'd be curious, obviously, to know what happened more in that legislative session, but that's a little bit of the background on it. Is it okay if I jump in with my comments about the exemption or not?
Yeah.
Okay.
Yeah.
So it's a tough one. And I think I have a hard time, like I said last time, but my view of it and trying to remember kind of who I am, but also representing prosecutors. And I know how they tend to feel about it, right? Is that when we have those situations where people are hesitant to report and don't report, and then we often then times see a bigger public safety problem because the person who's committing harm is not being brought to justice or investigated, and no eyes are on it and whatnot. We have a very paternalistic view of that. Unfortunately, we have to look out for the entire community, right? Regardless of whether the person might want that or not. I know Carlos can relate, right? And that we have a broader obligation, like kind of what Zane was saying, to children, to vulnerable people, to other members of the community completely outside of this person and their incidents. And at the same time, I struggle a lot with the idea of then taking away, obviously, the agency of a person and the specific connections that victim advocates have with that person, as opposed to some of the other mandatory reporters, right? And I recognize it's a different relationship. I don't support like a full exemption. I do think that ways that we can try to address the issue is to create more of a time frame, especially with domestic violence. I see domestic violence, and it seems like that is one of the biggest things, as those adults coming and being or not coming to receive services being a big public safety issue. And that whereas sexual assault, stalking, or well, it's hard because they overlap so much, but I see sexual assault advocates as a little different position. But to me, especially when we talk about and we think about Colorado's population, Gina put a little bit of it in the chat, but we talk about tribal communities, and we talk about the immigrant population and the fear that they already have of and the trust that there already issues there already are with law enforcement. That's where I like tend to lean more towards, okay, maybe some sort of exemption, maybe some sort of, like I said, time frame that allows for more of a process to be set up to protect those people and to instill the information to provide them with the information that they do have the ability to be protected by the criminal justice system. And I'm going to be very blunt, right? And I know I can. I don't think that the criminal justice system is spoken of highly in the community advocacy world necessarily, because fairly, we're not built for survivors, right? I look at websites though about reporting, and I see option not to report to law enforcement and a big law enforcement badge with an X through it. And that is very difficult, I think, for then criminal systems to feel comfortable removing and allowing removing the mandate and allowing discretion when we feel kind of like, well, the person's just going to be told, don't report. We're not going to have to report on your behalf. You aren't going to be, I think there's a lot of fear with that. And if we have more trust between those two systems, we are building more of a bridge rather than having the fear. So I say all that, I'm really bad, right? Like I should never be a judge because I just go back and forth and back and forth and back and forth. I say all that because I think that these are just different perspectives to consider. I also will be the legal nerd too and point out kind of on behalf of the advocates' argument. It's very interesting to me, right, that the definition for a victim advocate that's in the mandatory reporting statute refers to 1390-107, which is the privilege statute that Jennifer was talking about, right? So we're talking about that one statute policy-wise codified and said this group of people carries an incredibly special privilege that cannot be pierced, and it cannot be called to testify about their interactions with a survivor unless that person waives all of that. They have this incredible protection. And then we draw literally from that same definition and say, except they have to give information in these circumstances. Just kind of an interesting legal policy analysis. Like I said, I'm trying to be really fair. Like I feel a certain way for prosecutors that they shouldn't be exempted. I also see these other points and arguments and kind of legal fallacies that exist that support that idea. So that probably didn't help much, but that's what I've got.
No, I think it's helpful. I appreciate that you're not a judge, like you said, because you're but I think the wrestling piece is very real with where this group is. And I think that at the end of this discussion, I'm just going to do a quick kind of survey pulse taking, because I think right now it's just, it's helpful to just throw this and get it all on the table. And then at the end of the day, like we need to say like what you're most comfortable with. So that we can get a recommendation through one way or another. So I do have a question for this is overly simplifying, but I'm just curious because it came up in the last meeting, which was this like, don't forget that we could still report. We just wouldn't be mandated to report. And that was a thing that kept coming back from the panelists of like, this isn't to say that like we never would, or that we wouldn't see this as the best interest of the particular situation. And so therefore we would report. It's just giving us the option to not report when it's not the best situation. And so I wanted to like that's what keeps coming back to my mind from that conversation, because I can't remember who it was, but somebody had said, like, you know, that they were concerned that no one would report, and they're like, well, wait a minute, we would report, but we want the option not to, is more the leading piece here. Based on safety, based on, all the things that they've listed. So just want to like name that again, that's the kind of wrestling thing. It's not that would you never report or would you always report? It's somewhere in between, is what the group was kind of coalescing around last time. Jennifer, Soledad, then Zane, and then Kathy. Got quite the lineup. Go ahead, jump in. Jennifer,
You're
on
muted.
mute. Jennifer, you're muted, but I'm
I
sure
start talking and I'm
it was
muted.
good. It was good. It was good.
Thanks. I'm gonna focus on this 1995 piece, that this is when that went into law, and this piece about the legislative declaration that Jessica talked about, where the connection between law enforcement and domestic violence and sexual assault is very, very tight at that time, because this is the era when the Violence Against Women Act was initially passed. This is the era when victims of crime acts were being passed around the country. Colorado's, I think, was 1992. There was the assumption on two levels. One, that the answer to these crimes of gender-based violence was law enforcement and the criminal legal system, and that those systems and we as professionals knew better than survivors what they needed to do to protect themselves and their children. Over the past 30 years, we have moved very powerfully in a direction of recognizing survivor autonomy and recognizing that survivors know best how to protect themselves and how to protect their children, and that professionals don't. And I just want to give one legislative example of how we have addressed that in recent years. We had a statute, and we had some similar discussions to what we're having here today, that required that medical providers report to law enforcement if they believe that someone's injuries were the result of domestic violence. Now, to be fair, that's talking about adults. That's not talking about minors. It's a little different, but I think the larger context is a piece of this conversation and is important. For the same reasons we're talking about today, we fought to remove that statute, to revise that statute so that law enforcement was not called every time a doctor or another medical provider thought that the injuries were the result of domestic violence, and narrowed it very significantly to crimes involving weapons and, I believe, serious bodily injury. So, and that's a nationwide movement, and that's something that's been happening all over the country. So this is part and parcel of a shift in this world. We wouldn't be having this conversation. We wouldn't be having a mandatory reporting task force 30 years ago. The assumption was systems are the answer. So I just kind of want to put all of that in some historical context for folks.
Thanks, Jennifer. Soledad and Zane.
Yeah, thank you. So just to add a piece of history there, mandatory arrest was adopted in 1994. So, talking about the era, right, that we know better than everyone else. I think, and again, I'm gonna talk as an advocate that works directly with survivors. So one thing is that when and specifically about domestic violence, community-based advocacy, when we call CPS. We don't call law enforcement. So that first and foremost, when we have to report because we heard something on the crisis line, or we heard something on an intake when someone made it to shelter, we call CPS. Usually what happens is that a CPS, a social worker, a caseworker will come to the shelter or will go to the house and disclose that they received this report. If they're in the house, then they investigate the family, and then the abuser is made aware that this person was trying to reach out for help. So that's and that to say that that person hasn't received anything from the system to that point, except the fear and an increased danger, because if there's home, they're still with the abuser in there, and this things blows up, and and it's a mess. Second, if they are in shelter, they are forced to leave shelter if they have interviews, and that expose them and expose the children. And then the abuser have the possibility or the opportunity to talk with the kids, to instill fear, to coerce and control the survivor. So, and to that point, there's no resourcing, there's no help. Most of the times, after an initial interview, nothing happens. And the response from CPS is basically, you're safe, you came to shelter, nothing happened, and there's no investigation. Or they will say, you know what, leave. You need to leave to keep your children safe. So now that survivor that was trying to reach out for help is told by CPS, leave to keep your kids safe, but abuser is with them. So, and to that point, they haven't received nothing. There's no help. They're not giving them, a hotel voucher to leave and be safe. They say, call these numbers, community-based organization numbers, and look for help. Call this number, call Project Safeguard and file for a protection order. Call SPAN and see if they have a shelter. Call, Gateway and see if they have space. To that point, CPS is referring that survivor back to a community-based organization that they reach out in the first place, and they were forced, I want to say, to engage with the system that put them at greater risk, that make things harder, that added stress. And to that point, there's nothing. There's nothing. The survivor didn't receive anything other than the fear. And I want to say that, and I'm sorry, but I'm going to take a minute to share something, because there's also, when you're working with the system is a racist system, and you're exposed to the assumptions of whoever is working with you. And I hate to talk about specific cases, so I'm going to talk about myself. I was pregnant. I had preeclampsia. I went to the hospital in Boulder, and I went twice. The first time they draw blood, and I have huge bruises in my arms because that's what I do. And the second time that I went there, I had pancreatitis. I was like 8 months pregnant, and I wanted to understand what was happening to me. So I would keep asking questions like, what's wrong with me? What is the diagnosis, etc. And the nurse was a white person. The nurse said, are you afraid to go home? And I'm like, no. I just want to know what's happening to me. I want to have a diagnosis, and I want to know what the risk is if I go home. Like, am I going to die? Am my kids going to die, or whatever? That person didn't say anything to me, and they called CPS, they called a social worker, and they kept me there. The reason was that she thought that I was afraid. And also, she saw the bruises in my arm. And I was like, that bruise is from yesterday when you draw my blood, right? So I couldn't leave the hospital for the whole day. My husband was a student at CU. We were international students. What my thought is, when you are coming to CU as an international student, you go to this one meeting where they have a big PowerPoint, and they give you all the reasons why you will be deported, or that they will terminate your visa. So you see a picture of a plane taken off. So I knew that if I wasn't clear enough to pull my husband out of any suspicious, we could lose, he was pursuing his PhD, we could lose that opportunity that, he was at school. I thought that they could take my other kids away. I had 2, this is my 3rd pregnancy. I cried for a whole day in the hospital. I wasn't allowed to leave. I wasn't allowed to talk to my husband, because a white nurse thought that I was being abused. And the reason that I was asking all these questions was because I was afraid to go home. And the only thing that I wanted to do is go home, but tell me what I have, right? That to say that this system is not a good system. When we're forcing survivors to engage with the system, we're not giving them a solution. We're not making life easier on them. We're not saying, oh my gosh, we're not your stress. We know you're afraid. We know what you're dealing with, but here, let me add this that's going to solve the problem. No, this is something that is really taking the anxiety, the fear, and the questioning of the decision of seeking help in a different level of fear. And this is especially impactful in marginalized communities that are already afraid of the system, that they don't know how to navigate the system, and it put them at greater risk because also their partners don't know how to relate with the system. So I will invite you all to not to think about the general situation, think about those folks that will be most impacted by what we're deciding. Not, a white person that knows the system, that can talk clearly, that doesn't need an interpreter to communicate, that doesn't need extra support, that their status in this country is not at risk, even though they have American children. This is the people that is going to be most impacted by this decision. Anyone else can navigate the system. But me, even with my, kind of broken English at that point, I could communicate, I can express, and I can defend myself. But someone else maybe couldn't. And you are there and you're trapped, and probably, they would have reported me or my husband or whatever based on an assumption. So again, I think that the consequences are beyond what we live every day. And the fear that you see on, and I'm going to speak specifically about an immigrant survivor, when you're telling them I'm going to have to go CPS, the first thing they think, they're going to take my kids away. So I guess that's my invitation from a very personal perspective, but these things are real, and these things happen to real people. These things happen to me, and I'm here talking to you, So yeah, that's my invitation. I'm sorry I took that long, sorry.
Don't apologize. Getting a lot of love in the chat, Soledad. I really appreciate your willingness and vulnerability, sharing your personal story and perspective that I know is appreciated by the group. So really appreciate that. And again, don't apologize. Zane and Kathy, here's where I'm at, and I'll give you a chance to share. So we need to move into our panel discussion regarding the legal piece. I want to, if you have comments for the better of the group, happy to survey to see where folks are at. This is not an official vote of of a recommendation. It's so that we can better coalesce around how we are writing a recommendation, so that we can better understand where folks are at. So I want to resurvey folks while I have your time, and then I want to move us into the discussion with our panelists here and really kind of shift strongly in that direction. So Zane, did you want to, or Kathy, did y'all want to finish with anything before we take that survey?
Hey, Chase.
I just want to say that I guess this is a question for those that are working with survivors right now. Not every survivor you have is reported, right? I mean, there's just certain circumstances, and I just don't want to lose focus of that. I'm not. I guess what I'm concerned about is still the child safety piece. I understand everything that's been shared and absolutely respect that. And Soledad, thanks for sharing your perspective on that, because I think it helps us all grow and learn and understand. And I've seen where the system can tear families apart. I work in that system, and I've seen and we fight regularly with caseworkers and attorneys on when things are happening that just aren't in the family's best interest. But not everybody who seeks help is reported. And so I want to make sure that we're being clear that only in those circumstances where, so I don't know what happens behind the scenes. I don't know what happens when somebody calls, and I don't know why you tell them up front. I mean, I understand the mandatory disclosure part of saying that they could be reported, and I understand that could be a barrier, but not every family is reported. or every situation's reported. And sometimes there's children not involved at all. So, you know, domestic violence happens with, you know, childless homes too. So again, our focus here is on the child and the children. And that's kind of where I want to just make sure I'm not missing something, because I want to, you know, that's why I joined the task force was, you know, I just want to make sure that our children remain, you know, protected. And I want to strengthen victims advocates in that role. And so again, if somebody's seeking help, I feel like it's our duty and our responsibility to have statutory language that helps them, not hinders their help, while making sure that children remain safe. Sorry, thank you.
Thanks, Zane. Stephanie, I know you were jumping in, so I'm going to jump to you first, and then we'll wrap this. Go ahead, Stephanie.
Yeah, I mean, first of all, I just appreciate all the thoughtful comments, and I mean, yes, we're trying to create a balancing act here, right? Which makes, frankly, our entire profession in child welfare the difficult thing that it is today, right? How do you balance, you know, the protection and safety of children with the well-being of their families and having legal overlay on that? So it's complicated. I guess my question to the group is, you know, I agree with Jill's comment that by providing people or advocates an extension of 24, 72 hours to report, I don't think that solves the problem either. And I guess I'm a little hesitant, Trace, you're going to be angry at me. I'm a little hesitant to vote simply because have we explored the options between it's either one or it's the other? And maybe there are no options, but I guess I'm just uncomfortable because I don't feel like we have explored it. I had a quick chance to read the survey comments that you posted, Trace, but not thoroughly. And so I just didn't know if there was information in there that could assist us as we vote on this final issue. So I guess I'm just expressing, are there other options? And I'm asking Jennifer and I'm asking Soledad and, you know, what is it that we're not aware of potentially?
And by options, you mean like these other two scenarios that we had surveyed on. So the 72, the last conversation was around the 72 hour versus, well, we had talked about 24, 48, and they were like 72 because
right. I mean, I feel like we've we have these as opposing concepts, and I'm not convinced always in life that that has to be the case. Maybe it is. I'm sure people would disagree with me here on this issue. But I just don't know if there's other states. I mean, I know we have had other state research, so I guess I'm just asking, are there things besides either or? And because I don't think giving people a different time limit helps. I actually think it almost hurts at some level, just because it puts a deadline on something and it gives people, frankly, probably more anxiety to think that they're reporting on Monday and by Wednesday they better hurry up and have a plan because they're going to be reported on. So I actually think that's more cruel in some ways than just being honest with me up front and telling me what the game is, so I know what the rules are and I can make the decisions I need to make.
All right, here's what I'm gonna do then. I appreciate that. And Jennifer, sorry, I'm gonna we gotta move on. So here's what we're gonna do. We're not gonna survey right now. I think we need to rewrite the way we pose some of these questions based on Stephanie, your comments just now, but also some of the broader discussions. We can more creatively think about how to frame some of these questions to kind of draw some of those things out, like if not this, then what sort of thing. Because I think I think we can be kind of creative in how folks then feel comfortable voting and also expressing like specific concerns. Because again, we know that like any of our recommendations are not clear cut. There's always sub bullets. There's points around like, well, these things have to be true for this recommendation to be true, right? So we'll take a little bit more time to survey you all on this based on today's conversation and rewrite that more thoughtfully. Does that, Stephanie, would that kind of get at, okay, cool. So let's do that. Jordan, are you okay with that?
Yeah, I'm fine with that. And then I just kind of wanted to emphasize, you know, the survey that Trace is sending out is not the final vote on a recommendation. Right. The survey Trace is describing is just another information gathering iteration for us. So I didn't want anyone to feel like anything was definite if they're voting on what we're sending out. We're just trying to get more information on what we could put in the language.
Right. Yep. So just will say thanks in advance for being sure to check your email. We were higher than the data subcommittee, so props there, but I'd like to see 100% of folks so that we can actually move some things through and feel like we're being reflective of where the group is wholly. All right, so with that said, let's pivot. I'm actually going to take a risk and give you a short break because I think our brains we need to shake those a little bit, and then we're going to come back and we're going to have I'm counting on my legal folks to be efficient and concise because that's what you do for a living, right? I think so we're gonna come back at the 15 and we're gonna start with the panel, and they've kind of prepared, I think, a few remarks around um kind of what we are discussing, and then we'll kind of get us some key questions and start wrestling there, and we can go all the way up until the 50. So we'll have a good 35-40 minutes to talk. Cool. So come back at the 15, take a quick break, get some water, go to the bathroom, whatever, and we'll come back and jump in. Thanks, y'all. All right, y'all. Welcome back. Kevin's here. Hey, Kevin. Jill's here. Great, great, great. All right, cool. We'll give it one more minute. Bring folks back. Panel folks, appreciate your patience. Clearly, we are still wrestling. So thank you for, hopefully that gave you some insight. Obviously, there's some overlap here, I think, in these conversations for different reasons. So I think that'll give you some context as to where folks are and what they're kind of wrestling with broadly. So I'm going to hand it over. And when folks are back, if you're able to join on video, just so we know you're there, that's great. If not, no worries. But Jill, Kevin, and Chris are our panelists today, and I'm going to drop in just so that as a reminder which directive we're really getting at here. So Chris, Kevin, and Jill, I'm going to give you all a chance just to quickly remind folks. Chris, you are a proxy for Ashley. So I would love for you to just kind of introduce yourself so folks kind of know who you are. And then Kevin and Jill, just as a reminder to folks kind of where you're coming from as well. I think you all prepared some kind of opening remarks as to far like where you sit on this directive as the group, what you'd like for the group to be considering. And then we can get into some like kind of Q&A is what I'm thinking. So if you don't have, does everybody have kind of general remarks they want to share with first regarding this directive before we get into the Q&A? I'm thinking Chris, Kevin, and Jill. Is that right? Okay, cool. All right, Chris, why don't you go ahead and just introduce yourself, and then we'll do the quick intros with Kevin and Jill, and then whoever wants to start can jump in.
Great. Thanks for having me. I'm Chris Henderson. I'm the Executive Director of the Office of the Child Representative. So we're the state agency that contracts and employs all the attorneys who represent children in Colorado. So that previous conversation was fascinating, and I totally agree. I think there's some overlap. So, and I think, you know, the broad thing is that we are in agreement with attorneys aren't mandatory reporters, and anyone that works with an attorney on a legal team should not be a mandatory reporter, I think is the long and the short of it. I think it's really important too. I think most people on this probably know, but we're talking a lot about DNN, but in Colorado, children can be represented by attorneys in 12 different case types. And so this is a broader implication about domestic relations cases and things like that. So I am happy to be here. I think one of the things that I wanted to chat most about today is attorneys' rules of professional conduct and how that will affect kind of any of the decisions this committee makes. But I'm just grateful to be here, and Ashley gets to have a vacation, so I get to cover. So, and it's nice to see people, especially Jen Isle. I haven't seen you in years, so I'm happy to see an old friend.
Love it. Thanks, Chris, and thanks for joining us. I'm glad Ashley's getting a vacation, so that's awesome.
Yes, she's I think in Hawaii, if I know.
Okay, well, we'll be sending our best during this difficult time.
Exactly.
Yeah. All right, cool. Kevin, why don't we go to you next? Just a quick kind of intro reminder, and then we'll kind of come back.
You bet. So I'm at the Office of the Alternate Defense Counsel. I am a social worker. I am the social work coordinator for the agency. We have about 80 social workers working as independent contractors across the state. My role in the task force is one where it was an either or, the public defender's office or alternate defense counsel. And for those who are unfamiliar with ADC, we are what is referred to as conflict counsel for the public defender's office. So anytime the public defender's office can't represent somebody because of a conflict of interest, our state agency is the state agency that picks up that representation. So we're essentially public defender number 2. And I also hold the same position as Chris and Jill. And I think the question, and I'll just put this forward and then I'll hand it over to Jill, but the question about the exemption issue is one that's interesting to me. I think what we really hold true to is that attorney-client privilege means something, and does confidentiality and the attorney's rules do mean something. And I think that we're all advocating that those things prevail, that the privilege and confidentiality prevail.
Thanks, Kevin. Jill?
Hi, everybody. I am a social worker, like Kevin, and I work at the Office of Respondent Parents Council. And our agency is tasked with ensuring that all indigent poor parents in Colorado who have dependency and neglect cases filed against them have access to high quality lawyers. And at our agency, we think that high quality lawyering necessitates a team model so that parents who are struggling with domestic violence, mental health, addiction, poverty, homelessness, have a team behind them to really make sure they have access to the legal representation that they're entitled to in the state of Colorado. So in my role, I help connect our attorneys, and we have, over 250 contract attorneys around the state, help them connect to social workers and advocates who can join their legal teams and provide that high quality representation to parents. This model has been found to be the most effective and impactful way to represent families in the child welfare system. It's not just the ORPC that thinks it's great. It's the American Bar Association, the National Association of Council of Children. It's actually the Federal Children's Bureau that funds our model through federal 4A money. And like Kevin and Chris, our ask today is that this task force considers an update to the statute that permits anybody that is working with an attorney, contracted with an attorney, employed by an attorney, retained by an attorney to work on their legal team would get to prioritize privilege and confidentiality over reporting. So we're going to be able to answer questions about that, give examples of that. Hugely important topic for our folks and our teams, hugely important topic for our attorneys. Attorneys won't engage supports to help them do their job if those supports have to report. So yeah, that's my story, and I am happy to, Trace, if you want us to, we kind of talked about, Kevin, Chris, and I of having a bit of an organic discussion about it as opposed to like presenting formally.
Sure.
And also we're comfortable with like being interrupted with questions. Where we don't have like a set way we want to do it. So I'll defer to how you want us to handle it.
Yeah, I think I just want to make sure, and I think y'all are all like alluding to it, but I think something that was helpful in the last panel, like last conversation, was that like we were able to help first kind of define what the problem is from your perspective. So if you could just help us understand, like, so for instance, in the victim advocacy case, it was like safety of a client, right? Where it was kind of like, we're asking for this exemption because we feel like it like keeps people from, accessing resources. There's a safety issue that, that sort of thing. They kind of went down on that. So I just want to make sure that we're kind of clear on like what the like specifically what the challenge is from your perspective and like what the why, so that we can kind of get into then wrestling with that a little bit. So Kevin, if you want to jump in first.
Thanks. I think we talked a little bit ahead of time about what we kind of wanted to talk about. And one of the things that I think is important for everybody to understand is the right to an attorney, at least in the criminal system, wasn't actually afforded to folks until 1963-ish. That right is a constitutional right. So it's in the US Constitution that folks get an attorney if they can't afford one. And that's a relatively new development. We, as attorneys in this field, are protecting our clients' constitutional rights. And if we are forced to breach confidentiality and give information to law enforcement or to an outside source, that would be in breach of our client's constitutional rights. And so being placed in a position where the attorney has to hire somebody to fully represent the client, because that's what the standards are, that the attorneys bring in social workers and have an interdisciplinary team. It's contradictory to upholding the client's constitutional rights. So if we're forced to disclose information against our client's consent, it's a real problem. And we all have constitutional rights, and they should be protected for everybody.
And if I could just jump in, it's not only constitutional rights, but it violates the rules of professional conduct. I'm not allowed to disclose things that I learned in my representation. And I think it's important in Colorado. I just want to level set a little bit, because I think some people have been a little confused. You know, we have guardian ad litems. So those attorneys represent the best interest of the child, but we still have confidentiality. I can only break that if I believe it's in the child's best interest. That after the passage of House Bill 1038, where 12 and older in DNN are now have a traditional attorney-client privilege, it's not for me to decide if it's in their best interest at all. I represent my client in a traditional attorney-client way, and so I'm not allowed to disclose. With that being said, under the rules of professional conduct, both 1.6 and 5.3, there are times where an attorney can disclose things. So there is an opportunity to disclose. In the previous discussion, I think it was Jen or Stephanie talked about, we've moved in this state towards autonomy for families and letting families decide what's best for them and letting children decide that they're the experts on their whole life. That is the whole reason 1038 passed. And so I really want to honor families, and I'm just not sure how an attorney or a member of a legal team to be a mandatory reporter would absolutely violate the rules of professional conduct. And so I am reading the prior notes. And again, I appreciate everyone letting me jump in and come to a meeting when I haven't been a part of it. So I hope I'm not overstepping my bounds, but I'm just not sure how the rules don't trump everything else. This is the whole basis of an attorney relationship, is confidentiality and attorney-client privilege. And we have a number of examples of kids for the first time feeling safe to disclose things, for the first time coming up with plans that keep them safe. And I'm just speaking very freely. Children and families coming up with their plans is much better than professionals. We are not smarter than the families that we are working with. And so letting them come up with an idea of how they keep themselves safe, what's going to work for them, just shows them honor and respect. And the whole idea is treating families with dignity, and deciding that we know what's best for them is just not best practice.
Thanks, Christine. Before I come to you, Stephanie, I want to make sure I'm understanding kind of your question here and making sure that we're all on the same page. So you want to jump in, and then Jordan, I'll invite you to jump in too.
Yeah, no, I just, first of all, I always love hearing our friends talk about constitutional rights. You guys know it excites me. As attorneys, I understand you. I'm one of you. I respect the rules and that there are constitutional rights to be upheld. I just wanted to be clear, we are not talking about going backward on attorneys' obligations. We're focusing on their staff and employees or agents of them. So I just wanted to make sure I was clear as we proceed, because I don't think anybody here nor the directive is requiring an attorney to do anything differently than they currently do. Yeah.
Stephanie,
That's really, oh, sorry, go ahead, Chris.
I was just going to say that's really helpful. And that's, I think, where, you know, I'm even still, though, at 5.3, responsibilities regarding non-lawyer assistants. I still think agents of the attorney are covered under the rules of professional conduct when you're a member of the legal team. I think 5.3 is, well, and Stephanie, I'm preaching
clear
when I talk to you. But you're a much better lawyer than I'll ever be in my life. But
can you put that in the chat, Chris, for those who don't have that handy? That'd be fantastic. And yes, thank you, because I'm aware of that provision, but that's the piece that I think is really interesting as we sit here today and have this question. So I'll stop talking. Go ahead, Kevin.
Yeah, it's interesting too, the area where, and I forget the statute citation, maybe Jessica's got it, about privilege and who can be compelled. It talks about attorneys and everyone on their team. Essentially, it isn't updated enough to incorporate what's new in Colorado, which is that social workers are a part of the team. It's not new most of the places in the country at this point, but it's only been really very recently in Colorado that we've been doing this, but that they also are part of that privilege as well.
Zane, did you want to jump in?
I just want to clarify a couple of things. This is the world I live in too. And so we don't have in our jurisdiction, we don't have a lot of this. Chris, not most, but several of our guardian ad litem attorneys do have the SSPs working for them, but they're not necessarily social workers. They are people that are probably not mandatory reporters according to the statute. Jill, we don't have a lot of our respondent parent counsel that have teamed up, a couple, but not very many. So not everybody's taking advantage of this. And in our world, abuse is already, or neglect has already been alleged. And so if there's a re-abuse or re-neglect situation, I would like to know a little bit more clarity about, what the process is for that, because chances are the team's probably already going to be aware of that anyway. I don't know if there's already reporting going on. And secondly, there's also these professions that are working with your attorneys that aren't mandatory reporters anyway. So I'm trying to figure out what problem we're trying to solve. I understand the issue and I understand privilege and I understand all of those things. And Kevin, maybe your world's completely different, and so I want to be sensitive to that as well. But in the DNN world, I mean, we're already involved. We're here, so we're here to protect children. And so I want to, kind of keep my focus on the statutory changes and the reasons, what problem are we trying to solve here, in this regard, I guess is my question.
I answer it just for the differences in our agencies. My agency and the public defender's office both only contract with or hire social workers with a master's degree and LSWs or LCSWs. And I know that the other agencies have broadened kind of the scope of who works with folks at this point. And so I think that in particular, our agencies, one, the public defender's office was mandated to hire social workers in 2014. And so that is within their enabling statute that they were required to have social workers. And by title, Zane, that a social worker is anybody who graduated with a social work degree, at least in that strange wording of the language of the statute of who can call themselves a social worker. And so it implicates it for sure our agencies when the mandatory reporting statute specifically singles out social workers as a title, which is kind of what I've been harping on at the last however many years we've been meeting about the differences in the titles and the professions and who is listed as a mandatory reporter. We are by title implicated and mandated to be in the agency's employment, which is wild to think that the legislature would have considered that there would be this constitutional issue or problem. I'm only speaking from my area with the public defender's office and alternate defense counsel.
Can I share? So, you're right. This goes far beyond, I think, what our three agencies do, because there's also civil legal services, that do immigration, housing, elder law, eviction law, and all of these places employ or contract with social workers. It's a little newer in Colorado. However, I took my first case as a social worker working on a legal team to represent a parent in 2002 in New York City. And it was new then, although it wasn't new in the public defender world. And the reason it's important to us here today is because all of us either contract with or hire social workers to work on legal teams. It is correct that if you're a paralegal, if you are an investigator, if you are a peer advocate, and you are not otherwise mentioned in the statute, that you're not a mandatory reporter. And so you are easily accepting that you are keeping everything that your client tells you privileged on that team, meaning you will not share anything without the client's informed consent and the lawyer's consent as their agent. However, we do have social workers in our office. We have contracted with 20 social workers. I don't know how many case consultants that Chris has employed or contracted with, but there are also social workers working at OCR or contracted by OCR, obviously ADC, the Public Defender's Office, Colorado Legal Services, Rocky Mountain, all these places. So we are in a position where we have conflicting ethical issues. And the way that we navigate those issues in our offices is that we resolve ethical dilemmas just like any other nonprofit, state agency, legal services agency would do. And probably the three of us here on this call, and I know for myself, that is where I play a primary role with our legal teams. As lawyers call me and they say, Jill, or as agent of the attorney gets on the call with the lawyer, and we figure out how we can go home to our families at night and make sure that the humans that we work with during the day are safe. Nobody wants anybody to be unsafe. The reason that we're able to engage so deeply with the people we represent is because we do have that confidentiality. And I know that's what the domestic violence advocates like Soledad were talking about, which is so important. Because if a client relapses and they want to handle it on their own, they don't want to tell anybody, they don't want to be judged, they don't want the caseworker to report it to the court, they're not going to tell anybody unless they know that there's somebody that they can trust. And I'm somebody they can trust because I don't have to report. And it could be that they have an overnight visit coming up, Zane, and they relapsed. And if they can tell me, and I can help them to get back into treatment, and I can help them to convey what's happening to the professionals on the case, then they're going to have a way better outcome, that child and that family, than if they kept that to themselves and, didn't disclose it, didn't deal with it. It gets found out later in an ugly way, right? By a caseworker getting a UA a couple of days later, or missing a UA, or whatever the case may be. We are able to engage people to make better decisions for themselves and their families because they know that they can talk to us about it. And if we're so conflicted that we might have to make a report, the attorneys will not engage social workers in the representation. They will not do it. So instead of me, a skilled clinical social worker, who can talk I can assess suicidality. I can create a safety plan for domestic violence victims. I can help people get the resources they need to best be in their best selves for their families. And if the parents are denied that, if the attorneys are denied that, it's the attorney that's doing it, because the attorney is not going to report, but they're not going to have that skill set. And so it's really this amazing bonus to people to be able to have a team on their side. And when the domestic violence victims were talking earlier, I was just thinking to myself, gosh, knowing what I know about the system, if I needed domestic violence help, I would only call a lawyer. And I am a white upper middle class lady, and I would call a lawyer, and a lawyer would never be able to disclose what I'm telling them about my domestic violence situation. Why can't we afford that same thing to our most marginalized communities? We know we have an overrepresentation problem in our systems, in our criminal justice system, family court, juvenile court system, policing systems. It's ableist, it's homophobic, it's racist. We know that. That's why we're here today, right? We're trying to fix some of these things. And if we're feeling a little uncomfortable with making some of these changes, I think we're in a good place. Because what is happening now isn't working. So let's be a little uncomfortable. Center the family, center the parents, center the children, by allowing them access to a truly confidential advocate. And that's what we're here to argue for today.
Jill, I appreciate that. I want to, and Jessica, just sorry if you wouldn't mind if I just want to make sure I'm steering us in the right direction. Stephanie, I think your comment at the end is really helpful to kind of recenter on around the background piece. So can you just clarify, like, the question here is then maybe why doesn't Rule 5.3 trump that, like, what we're getting at here? So I just want to understand your kind of prompt there and bring you back in to make sure that we're understanding historically why this directive came about and making sure that we're answering that question.
Yeah, it's kind of funny because this question came up during the stakeholdering for this task force. And actually, Chris, I think your organization had raised it. And several of us were like, what? We don't need to do that. We've got rules of professional responsibility that incorporate your people onto your teams, to which then many people were like, yes, sort of. But it isn't listed in statute, which makes not only the individuals pretty nervous, but it makes our lawyers nervous, because if they're responsible for ensuring that certain rules, confidentiality, et cetera, are upheld, and it isn't specified in statute, does that even compromise the lawyer, not just the person on the team? So, and make them have to be reporters. So I'm laughing because it was one of those legislative decisions where I was like, I don't know, I'm tired, it's overwhelming. Put it on the task force. And that's why we're here today. To frame up the issue, I think, at least as I understood it, and I think everybody here has touched on this, is the real question is, do we need to put in, like, all staff associated with attorneys, right? Are they exempt from being mandated reporters, versus relying on these different little pieces of rule that protect the attorney from not being a mandated reporter? And we think by extension covers their team, but it is not explicitly stated. I mean, I think that's the ultimate question, is how specific should this mandated reporting law be as it relates to this issue? Does that help, Trace?
Yeah, super helpful. And I think, and Joe, I want to say what Kelly said. I really do appreciate your, and I wasn't trying to just jump in on your comment and then steer us elsewhere, but I just want to make sure that I'm understanding kind of the crux of the question and the issue here. And so, Chris, I wonder, if your organization's the one that kind of brought this up, I want to make sure that, what's your response to what Stephanie just said of, like, to this question, do we need to put in all staff associated with the attorney's piece? Like, what are you asking for here?
Yeah, I just put in the chat, Stephanie was talking proposed language that I think all three agencies have kind of vetted and thought would clarify exactly what needs to happen, because an agent, a team member, a member of the legal team, and obviously everyone can read it, but I think this is just very simple, quick language that would just resolve any of these kind of issues. Because Stephanie is absolutely correct. Attorneys are concerned. Are they going to get grieved if a member of their team violates the rules of professional conduct? And, I think it's just so important to share that, again, the confidentiality piece doesn't make a child unsafe. Those don't go hand in hand in working with families. And so, but I see Jen has a question, and I think other people have hands up, but and Kevin and Jill, you guys have been a part of this much longer, but I think that is the last language that the three of us our three agencies landed on.
I love suggested language, Chris. Love the concreteness here. Jessica, you've had your hand up for a while, so jump in, and then Jennifer, I know you have a question about the language itself. So
I would push it to Jen to keep consistency with the convo, and then I can come back. I have a much shorter comment.
Okay, cool. Yeah, Jen, what's the question?
So I'm a little bit concerned with the course of legal representation language, because I think for a lot of agencies, they may not be representing that person yet. There might be a person doing intake. There might be a person providing victim advocacy services before a lawyer is engaged, but it is still at a law firm level. So I think we might need to parse that a little bit in the course of providing legal services, or maybe something just a little broader than legal representation.
I like that, Jen, and I think I saw another state that had it that was a little bit more expansive around intake or preparing to engage in or something like that, I'd be happy to look at that.
Yeah, Jen, I totally agree. I think that makes a lot of sense.
Okay, that was easy enough. Love that. Jessica, go ahead.
Okay, I think mine's pretty easy too. I appreciate the conversation and Stephanie providing the background, because that was my question, is like, is there a controversy over whether this should happen, or is this kind of sort of generally understood to be the law of the land, but there's still, confusion over it because of the statutes and the rules of professional conduct. So I think I got that answered. So I guess to me, it makes sense. I don't think there's controversy over the fact that these staff should be included in confidentiality and not considered mandatory reporters when when they are providing services in that role. My one other question, and just to kind of provide more information too, of course, district attorneys are considered peace officers, our DA investigators are peace officers. So we are all mandatory reporters. Our staff is not rolled into that. And I think under the rules of like a professional conduct, there's argument there, but that's not what I'm here to chat about. I just want to kind of lay out from my perspective. I've never had to deal with the idea of not disclosing anything, because that's what we always do. The question I have, and it's probably mostly for Kevin, is are there post-certified peace officers that you guys employ as investigators, or that the PDs employ investigators? And then would they then be exempt, you think, under this under this language?
I'm gonna have to almost ask where maybe Carlos and you can tell me what a post-certified peace officer is, but have we hired former police officers or contracted with former police officers? I'll tell you that probably yes, for ADC has contracted with former detectives, police officers, and other folks. I think is there a question around whether they are part of a legal team that is representing someone when they're doing the work of the agency? I don't think there's a question. I think that they are covered by attorney-client privilege. And so I'm guessing at what you might be suggesting is that we also add them to the list, or that we make sure that they're covered as well.
Mostly that I want to understand, we're kind of talking mostly in the context of advocates or social workers who are mandatory reporters. And I just want us to be thinking about the other people that might fall under that list as being agents, and whether or not, I'm not really going for one way or the other. Right now, I'm just like thinking, okay, wanting to be broad with how we're thinking of those people. So,
I think to me, and I don't know if you feel the same way, but this feels like a cleanup or a clarification that will kind of make it clear for anybody who has the question that this attorney-client privilege does mean something, and that it's sort of regardless of the licensure, kind of like what Jennifer was saying, that if you're employed by an attorney or contracted through an attorney or an agent of the attorney, that you can uphold that client's rights.
Okay, yeah, I think that makes sense. And I think the cleanup language helps me understand it. I just wanted to be thoughtful of all the people it might pull in, but it makes sense with the umbrella of privilege. Okay.
I just wanted to point out that even though I do think this is cleanup, and I appreciate your perspective, Jessica, because I have been working in this field for a long time, and I have never heard of a social worker working with a lawyer be prosecuted for, failing to report. I haven't. That said, many of my colleagues across the country operate in this sort of gray area, and having the clarification really would be such like a beautiful burden lifted from me as somebody who feels responsible for social workers and their licensure and their careers, and I care about them. And so, for myself, I feel like I have had to navigate this for a long time, and having the support of this subcommittee would be very meaningful to many, many social workers in Colorado. And so it's just wanted to put that out there, that even though for some of you it seems clear and that's wonderful. I'm just wanting you to know like how much it means to us that we would be able to potentially include this in a mandatory reporting update.
I'm gonna real quick, thanks for that, Jill. And I think that's a great, I'm gonna count that as your kind of closing comment, if you don't mind, because we got to get back to the main room. Kevin and Chris, I want to just offer you the opportunity to just kind of wrap it up with a minute or less kind of comments of as this group considers. Sounds like we've got some real kind of momentum to move from to draft some recommendations around. But anything you want us as we sit with this to just kind of keep top of mind from your perspective.
I just, appreciate the conversation. And most importantly, I just know families are better served when we do a multidisciplinary team. And so by making sure we can continue that in Colorado, and to Jill's point, making sure that social workers feel safe and people of the legal team feel safe in their role would go such a long way. And it's going to keep families and kids better served and more safe, in my opinion. So I appreciate the conversation.
Great, thanks, Kevin.
Just real quickly, I agree completely with what Chris and Jill both said, and that this really is about protecting the most vulnerable folks that we have. Many of our clients also have been victims, and we know that the system disproportionately impacts people of color, LGBTQI, and people with disabilities.
And then Jill, I know I said that was your closing comment, but anything else you want to add before we jump?
Thank you. I'm good.
Okay. Well, again, really appreciate the discussion today from everyone. I think we had a lot to cover, but I think we covered a lot. So thank y'all. I'm gonna drop in. There we go. Jordan dropped it in. I'm gonna drop in. That's heads us back to the main room. If you wouldn't mind joining just for a couple more minutes to make sure we don't have public comment. We'll be following up via survey as a reminder, just to make sure that we understand where folks are at. So just appreciate your participation on that, and we'll see you back in the main room.
Okay, I'm gonna end this call. Is everyone okay with that?